Students will start the meeting in 5 minutes, so keep joining the meeting and do send in the WhatsApp group.
Welcome, Kirpan ma'am.
Good evening, sir. Good evening.
Ma'am, you're not audible.
Still not?
Just yeah, you're audible, ma'am.
I I have unmuted. Am I audible now?
Yes, ma'am. You're audible. Okay, we'll just start in 5 to 10 minutes, ma'am. Students
Yes.
are
All right.
yes, ma'am. Okay. Sir, shall we start?
Yes, we can start. Am I audible?
Yes, sir. You
Okay.
are.
So we'll be starting the session with the introduction. Just a minute. Good morning, everyone. Good afternoon, everyone. न्यायपथेन गच्छाम धर्म मार्गम अनुस्मृता निर्णायका प्रकाशन्ते सत्य स्थिता मनोदया. हम न्याय के पथ पर चलते हैं, धर्म के मार्ग को स्मरण करते हुए निर्णायक प्रकाशमान होते हैं, जिनका मन सत्य में स्थित होता है. On behalf of Bharati Vidyapeeth Team to be University New Law College Pune, it gives me immense pleasure to welcome you all to Saamanjasya, the arbitration skill and capacity building program. We are fortunate to be guided by the vision and encouragement of our Dean and Principal Dr. Ujwala Bindale ma'am, our Vice Principal Dr. Jyoti Dharm ma'am, and our IQAC Coordinator Dr. Vidya Dhere ma'am. My sincere appreciation to my colleague Dr. Rohit Suravase sir, without whom this course could not have been possible. Rohit sir, over to you.
Thank you, sir. So, a warm welcome to Nirnayak, the third session of Saamanjasya, the arbitration skill and capacity building program. Today marks the third day of the wonderful 7-day course on skill and capacity building on arbitration. It is an honor to welcome today's resource person, Advocate Kiran Dhaliwal ma'am, a legal academician and practitioner with a strong focus on arbitration and contract law. She holds a LLM from Nalsar University of Law and BA LLB honors from RGNUL Patiala and UGC NET qualified. Ma'am has worked closely with Dr. Ajay Rao at ANR Law LLP and RAB Associates LLP, assisting in arbitration cases, drafting uh, complex commercial contracts, and contributing to the leading publications on arbitration and contract drafting. Ma'am has conducted workshops at top law schools, including NLSIU, NALSAR, and Nirma University, and has served as an arbitrator in multiple national and international mock arbitration competitions. So, with this small introduction, I would like ma'am to take over the session. Yes, ma'am.
Good evening, everyone.
Good evening.
I believe, thank you for the warm welcome, Rohit sir.
Thank you, ma'am. I think so, ma'am is facing some technical glitch. We'll just wait for a minute.
There's a technical glitch from the ma'am side. She will be joining soon. Please stay. I guess ma'am has joined again. Kirpan ma'am.
I'm very sorry. I had a little bit of a connection problem.
Yes, ma'am.
Thank you so much for the warm welcome, Shubham sir and Rohit sir. As far as I know, you had two sessions on the introduction of ADR as well as a brief introduction of arbitration as well. I will be covering specifically jurisdiction and arbitrability of disputes and also appointment of arbitrators in today's session. I've also had good feedback about the class being very interactive. So if we could quickly recap whatever we've discussed so far in the last two sessions, preferably whoever has been participating in the previous two sessions, please. Anybody? Can you highlight the important sections in the Arbitration and Conciliation Act, please? Chat, you want to talk? I'm open to either of those. Please. So far? Okay, maybe once we move on with what we've discussed today. The first thing that I will be discussing, should I share the PDF of the Arbitration Act, please? If I could, I can
Yes,
share.
ma'am. Yes, ma'am.
Just a second. It's not permitting me to.
Is there any problem in sharing the screen?
Yes, I am having a little bit of a problem.
She's having problem.
व्हाट्सएप कर रहे ना कि बोला क्या है
Ma'am, can you share the
Anji,
PPT or
I'll
document
just.
on WhatsApp? Yeah.
Is it visible?
Ma'am, it's visible actually.
हाँ
Yes.
Yes, ma'am, it's visible.
Okay. So the first part that we will cover today is jurisdiction specifically. I have just turned off my video if that's okay because the network keeps becoming broken up.
Fine, ma'am.
Yes. Now, specifically, Section 16 There are two concepts in this particular section. That is, one is your doctrine of competence, and one is your doctrine of separability. Just a second, I'm just going to quickly read section 16. Yes. Now, this specifically provides, and as far as now I'm moving on the assumption that everybody is clear that arbitration is specifically based on party autonomy. Yes. So, as the intention of the parties is to opt for arbitration and specifically remove the jurisdiction of the courts, that is, वो चाहते हैं कि उनकी dispute specifically एक neutral third party determine करे and not any court, because as may have been discussed already, courts are expensive, they also take up a lot of time, it is a very rigid process as well. What arbitration permits is some sort of flexibility and also a little bit of trust in that neutral third party कि हाँ ये हम दोनों की बात equally सुनेंगे and उसके basis पे ये हमने ही appoint किए हैं उसके basis पे ही ये particularly हमारी dispute determine करेंगे. Now specifically section 16 provides that the arbitral tribunal may rule on its own jurisdiction, including ruling on any objections with respect to the existence and validity of the arbitration agreement. This is part one of this particular section. We're going to divide it into two parts. One is going to deal with specifically the principle of competence, and that can be spelled as specifically as competence, or the German version, which is KOMPETENZ and competence. So this specifically provides that सबसे पहले the primary right to determine the jurisdiction, whether a dispute falls within the jurisdiction of that arbitral tribunal or not, is with the arbitral tribunal. Now, this might seem कि ये तो principle of natural justice जो है, nobody shall be a judge in their own case, इसके violative है. But what we are trying to do here, यहाँ पे specifically court की jurisdiction oust नहीं हो रही, बिल्कुल खत्म नहीं हो रही, but थोड़ी delayed है. Because जब आप section 16 के अंडर jurisdiction determine हो जाती है, what may then happen is कि आप उसको बाद में challenge भी कर सकते हैं at the stage of setting aside the arbitration award at section 34. So all we are doing under 16, and that is कि obviously arbitration proceedings चल सके, जो मौका है arbitration को एक मिल सके, which is what the intention of the parties was. That is that yes, we have determined जब हमारा ओरिजिनल कॉन्ट्रैक्ट हुआ था जिसमें हमारा डिस्प्यूट रेजोल्यूशन क्लॉज है, उसमें स्पेसिफिकली हमने पार्टीज ने अपनी मर्जी से ये कंक्लूड किया था दैट यस we want to go for arbitration to resolve our particular disputes. If that particular purpose is defeated because arbitration की jurisdiction, arbitral tribunal की jurisdiction court determine करने लग जाएगी, and obviously डिटर्मिन करने के लिए फैक्ट्स में जाना पड़ेगा, मेरिट्स में जाना पड़ेगा. एक डिस्प्यूट jurisdiction is what? So in civil cases, there are two kinds of jurisdiction. Three, in fact, courts की. One is territorial, that is territory based, आपकी demarcated है according to the rules of that particular high court. Two is pecuniary jurisdiction, which is given in our statutes. And number three is your subject matter jurisdiction. Again, that court might have specific cases that it might hear. For example, negotiable instruments के अलग से court होते हैं, family court अलग है, एक POXO court है, that is subject matter jurisdiction. And to actually determine that jurisdiction in a civil case, you have to look at the facts. कौन सा subject matter है, कितने pecuniary jurisdiction है, all of those things. Those are फिर वो preliminary नहीं रह जाती. One associated thing now, because I am starting in the middle of the act, one associated concept here is कि courts actually कितने हद तक एक dispute को arbitration में refer कर सकते हैं. Just so I have some clarity, has section 8 been discussed? Section 8 and 11 yet? If you could respond in the chat box, please. Yes?
No, ma'am. Section 8 was not discussed. Section 7 was discussed.
7 was discussed. Okay. So yes, we'll have to quickly refer to 8 as well because see, that is the stage where the court is going to come into the picture into our arbitration process. I'm just quickly going to. Now, what may happen? So you've discussed 7, correct? In that, you are determining whatever is an arbitration agreement. What happens in section 8 specifically is that it might happen that one of the parties जो arbitration के लिए नहीं जाना चाह रही है वो जाके कोर्ट में उस पर्टिकुलर सेम डिस्प्यूट पे जाके एक proceeding file करते petition file करते yes but the other party knows that we already have an arbitration clause वो कोर्ट में जाके एक सेक्शन 8 की एप्लीकेशन फाइल करते हैं जिससे it is basically an application to the court which states that हमारी एक arbitration agreement है उसमें ये पर्टिकुलर जो सब्जेक्ट मैटर जिसके लिए पिटिशन इस कोर्ट के सामने फाइल हो रही है वो उसमें कवर्ड है so please refer our dispute that your jurisdiction we have ousted for the time being please refer us to an to that tribunal or to arbitration because that is what we have decided as the party इसका purpose basically ये है कि जब एक party जब main see there is please understand I'm going to try to please understand there is so the when the main contract is being executed by the parties they may have included whatever arbitration clause back then a dispute might arise later on hello am I audible I think I got stuck in
Yes,
the video so I'm just going to turn that off
ma'am, you're audible.
yes so a dispute might arise much later which is why a party later on might try to circumvent that particular arbitration clause. मुझे लगता है, and ideally, if you look at it in practice, and when you are drafting an arbitration clause, see, if you are a party who's going to suffer some sort of loss in during a transaction, please note a transaction may run into years. A contract may run into years. जो supply के contracts होते हैं. Yes, 5, 10 years. So throughout that period of time, if you think that you are somebody who wants quick action, अगर कोई dispute arise होती है, कुछ breach होता है, you are somebody who wants to include an arbitration clause. And you want to include a wide arbitration clause कि हर तरह की dispute उसमें cover हो सके. Because आप court नहीं जाना चाहते. Court में there might be a stay on your operations अगर आप कोई manufacturing unit है. There might be a stay on your particular operations. There might be delay in your obligations to maybe third parties as well because of that particular stay. And obviously, there is the problem of your reputation in court because those are all public proceedings. For obviously, I don't know if you would know about the Johnson and Johnson case where the powder was deemed to be cancerous, was found to be cancerous, in fact. Johnson & Johnson suffered a big, big loss in their reputation after that. So yes, for somebody who wants to have those, that some dispute or breach might arise, which affects your business operations. If you are their lawyer, you are drafting their particular contract and you are negotiating all of the terms, specifically legal terms, because mostly these businesses are just concerned with what are their commercials. उनको कितने पैसे आ रहे हैं, कितना काम करना है. They are not going to look into these particular things. It is for you, जिनके आप lawyer हैं, contract drafter हैं जिनके. You have to look at the fact कि कल अगर कोई dispute arise होती है, मुझे फायदा है कोर्ट जाने में या मुझे फायदा है एक out of court settlement mechanism use करने में, which may be ADR, because that is quick, it keeps the confidentiality, and it is going to be certainly faster than court, and also maybe more, less expensive than court, but we've moved away from that because आजकल arbitrations are happening in fancy hotels, fancy conference rooms. Yeah, so that the question of it being inexpensive is questionable, in fact. So yes, when a dispute arises, a particular party might move court. आपको वो प्रिवेंट करना है क्योंकि हमारी तब बात हुई थी, हमारी अग्रीमेंट है that we want to opt for arbitration. तो सेक्शन 8 एप्लीकेशन आप फाइल करेंगे, particularly a judicial authority before which an action is brought in a matter which is the subject matter of an arbitration agreement. So it has to be covered by the arbitration agreement. Only then can you get it referred to arbitration. Shall, if a party to the arbitration agreement or any person claiming through or under him so applies not later than the date of submitting his first statement on the substance of the dispute. That is either your written statement, whatever first application that you might file before that court as a respondent, then you have to particularly file this Section 8 application, and this is a mandatory provision. So court has to refer the parties to arbitration unless it finds that prima facie no valid arbitration agreement exists. All the court has to do at this particular stage is to see if a prima facie arbitration agreement exists between the parties. I will not get into the details of how validity of an arbitration agreement is determined because we might be short on time. But court goes on the face of it. I hope everybody understands prima facie. That's on the face of it. See whether an arbitration agreement between the two parties exists. For that matter, obviously, the court has to look at अगर parties दोनों same हैं, subject matter same है, and वो arbitration agreement section 7 के साथ comply करती है कि नहीं. क्विक क्वेश्चन, सिर्फ सेक्शन 7 के साथ कंप्लायंस चाहिए या सेक्शन 10 कॉन्ट्रैक्ट एक्ट के साथ भी कंप्लायंस चाहिए? Anybody may answer. Chat box, or you can unmute yourselves, please. What is an arbitration agreement? It is a contract. And does a contract not have to comply with section 10 to be a valid contract?
Yes, ma'am.
So yes, so both the things have to be seen, valid and only on the face of it. See, they can't start going into the details of the dispute between the parties because वो काम तो arbitral tribunal का है, not the court. So specifically section 8, for your purposes, relevance, it's only this much. Why? Because court is coming into the picture once a dispute has arisen. Even under section 11, yeah, parties, we'll come to that though, when parties can't appoint an arbitrator, they can't agree on an arbitrator, then they can apply to court to appoint an arbitrator for them. So the court is a relevant party. I mean, not even a party, but is relevant in the arbitration process. I've often had questions asking if arbitration is a parallel process to the court system. Not entirely, but it is expected that court will intervene as less as possible because parties, again, the basic fundamental understanding of arbitration is that the parties have agreed to opt for arbitration. The parties have agreed to a procedure. The parties have agreed to a timeline. They have agreed that, yes, we don't want to go to court. So that has to be upheld time and again. And courts do not have to intervene. Intervention is still okay. Interference is what becomes problematic. And in Indian jurisprudence, we have had courts interfering quite a bit. And we've slowly moved on to a pro arbitration stance. But we have faced a lot of situations where courts have, again, forced their traditional views of arbitration, and sometimes court tend to take it to their egos as well, that how is it that we don't have jurisdiction in a particular case? So yes, party autonomy is supreme, and whatever the parties have agreed upon, that is what the court has to do, and that is what the tribunal also has to do, because the parties are appointing this third person to decide their dispute. So far, 8, and we're going to go back to 16 so that we can understand why are we excluding the court here. Now, Section 16 specifically provided that it is the arbitral tribunal that is going to rule on its own jurisdiction and not the court. ये जो existence of arbitration agreement है, existence or validity of arbitration agreement, even this will be determined by the tribunal and not the court under section 8 or 11. उन्हें सिर्फ prima facie देखना है कि एक arbitration agreement between the parties है या नहीं है. Now, why this is important? Because again, coming back to the fact that parties have agreed that we are going to appoint a neutral third party to decide our dispute, we are laying down the particular scope and the jurisdiction of that tribunal. ये subject matter है, वो सब clause में लिखना है. I hope that was covered yesterday. And that is how that tribunal will actually get a chance to determine the dispute. Otherwise, अगर courts के पास चले गई, courts will start looking into the merits of the case. तो फिर वो parties की जो intention थी और autonomy थी, that becomes wasteful and futile entirely. Now, any questions so far on competence? Anybody? No? Okay. Now, yes. Okay. With respect to the existence or validity of the arbitration agreement, and for that purpose, subclause A, an arbitration clause which forms part of a contract shall be treated as an agreement independent of the other terms of the contract. Now, this is what doctrine of separability is. Please note, an arbitration clause is probably going to be a clause in a main agreement. Correct? Dispute resolution का clause होता है जिसमें parties determine वो contract main contract में होगा. The main contract is whatever the transaction is related. उसमें they will probably include a clause that says all disputes relating to or arising in connection with existing disputes and even any disputes in the future arising in connection with the obligations under this particular agreement, any breach, anything, existence and validity of this contract will be subject to arbitration, and then whatever else they want to specify in that clause. Now, why are we particularly specifying that the clause which will be a separate or independent agreement? Because what may happen is when a dispute arises, one of the parties may claim that this particular contract is invalid. It might be short on some particular essential or something that challenges the very validity of that main contract. When that validity is challenged, which means all provisions of that contract are being challenged, which means that you cannot actually particularly enforce that contract until and unless you determine कि वो contract valid भी है कि नहीं. और अगर यही चीज हो गई and all of the provisions become have to be in a limbo because we can't enforce them जब तक validity नहीं determine होती, और वो validity will be determined by who? When the parties have specified an arbitration clause, it should ideally be that arbitral tribunal. But अगर हम इस particular concept को include ना करें, तो उससे वो arbitration clause भी invalid हो जाता है या limbo में तो आ जाता है, उसकी भी validity question हो जाती है. तो फिर the only recourse left to the party is to go to court. But that is what parties specifically didn't want. So which is why to actually give a chance to to arbitration, to actually uphold the autonomy and the decision of the parties to opt for arbitration instead of court proceedings, we have tried to shield that particular arbitration clause by the doctrine of separability from any infirmity that might affect the rest of the contract. Yes? I will try to... So you can think of it as a big circle, that big circle having a smaller circle within it, which is shielded from anything that might affect the big circle. That big circle being the main contract and that smaller circle being the arbitration clause. So far with me? Any questions? No? Okay. Now, clause B, a decision by the arbitral tribunal that the contract is null and void shall not entail ipso jure the invalidity of the arbitration clause. Now, this is also connected to the doctrine of separability only. When the arbitral tribunal has determined कि हाँ जिसने challenge किया था वो main contract as being invalid, that arbitral tribunal determines हाँ main contract invalid है. जब if the doctrine of separability didn't exist, उसमें फिर ये particular clause भी invalid हो जाना था by virtue of being part of that particular main contract. Now, if that is the case, then तो फिर arbitral tribunal का basis ही खत्म हो गया. Where is the arbitral tribunal getting its power to determine the dispute? That arbitration clause. अगर हम उस arbitration clause को नहीं protect करेंगे, तो there is no foundation left for the arbitral tribunal. So the determination by the arbitral tribunal whether a contract is valid or invalid, it does not by the operation of law make the arbitration clause also invalid. वो shielded है from any determination with regard to the main contract, with any determination with regard to the validity of the main contract specifically. These are two aspects of the doctrine of separability. The first part of section 16 talks about competence, that it is going to be the arbitral tribunal itself. Now, there was a question that has often arisen is that जब एक contract की validity ही हम question करते हैं, तो वो validity किसके पास जाके question करेंगे? वो आर्बिट्रल ट्राइब्यूनल के पास ही जाके क्वेश्चन करेंगे. आप वो आर्बिट्रेशन एग्रीमेंट को इन्वोक करेंगे. You will appoint your arbitrators, and that because your dispute resolution mechanism is protected by virtue of this doctrine of separability, which is protecting your particular arbitration clause from any infirmity, any sort of invalidity that you might claim against any other clause of that particular contract. So far clear?
Yes,
Now,
ma'am.
Yes, ma'am.
a plea that the arbitral tribunal does not have jurisdiction shall not be raised. Now, shall not be raised later than the submission of defense. However, a party shall not be precluded from raising such a plea merely because that he has appointed or participated in the appointment of an arbitrator. There are two instances, actually two time periods where this plea of jurisdiction can actually be raised. One is obviously जब tribunal appoint हुआ है, constitute हुआ है. That is when you would raise a dispute that इस tribunal के पास, तो इस subject matter, इस dispute के subject matter के लिए particularly jurisdiction ही नहीं. So that would happen obviously at the first instance, not later than the submission of defense. And that is usually within 6 months. Statement of claim and defense is usually done within the 6 months, first 6 months of appointment of an arbitral tribunal. However, now because both parties participate in the process of appointment of arbitrators, just because you have participated in the process of appointment of arbitrator, you will not be excluded, or you are not, there is no then restriction. ये कोई stopple नहीं लग जाता कि आपने तो अपॉइंट किया था, अब आप उनकी particularly appointment या उनकी jurisdiction challenge नहीं कर सकते. Please note there are two differences between there is a difference between appointment of an arbitrator and the jurisdiction of the tribunal. Appointment of an arbitrator, you are choosing a particular individual to be part of your tribunal. Jurisdiction relates to उस particular tribunal को किस matters पे actually dispute resolve करनी है. What are the particular areas or categories of dispute that are falling within the jurisdiction, and that will be determined from your arbitration agreement. जो कुछ आपने arbitration agreement में specify किया होगा कि हम ये disputes, existence, validity, breach, and you could even specify कि सिर्फ only disputes involving an amount of money more than 10,000. So particularly your contract, your agreement will determine what is the jurisdiction of that particular arbitral tribunal. Now, the second thing, that second point of time during arbitration proceedings that a dispute with regard to the jurisdiction might arises, A plea that the arbitral tribunal is exceeding the scope of its authority shall be raised as soon as the matter alleged to be beyond the scope of its authority is raised during the arbitral proceedings. Now, for example, there might be certain kind of disputes that you have subjected to resolution by arbitration, and there might be certain set of disputes, category of disputes, जो आपने scope of arbitration से beyond रखी हैं. It could be a pecuniary jurisdiction, it could be a subject matter jurisdiction. You might have said that any disputes that involve more than 10 lakh rupees, that is subject to arbitration, and anything below that is going to go to court, or other way around. That is, again, parties की मर्जी है. When you, during the proceedings, there might come a time where you think that the arbitral tribunal is now trying to resolve a dispute which involves money or an amount that is less than 10,000. Because see, in a transaction, and in today's world, transactions are very complex. One is probably connected to the other. So in that matter, the jurisdiction, the dispute might be connected to another dispute. But that other dispute might be beyond the particular jurisdiction, the scope of jurisdiction of that tribunal. So for that particular matter, जो बियॉन्ड है, तो प्रोसीडिंग्स के दौरान भी एक पॉइंट ऑफ टाइम आ सकता है जब एक पार्टी को लगता है दैट दिस पर्टिकुलर डिस्प्यूट इज नॉट विद इन द स्कोप. इट कुड हैव टू डू विद फ्रॉड, इट कुड हैव टू डू विद पर्टिकुलर any other criminal matter, and that will probably come to light jab as in when parties present their case. Have we discussed arbitrability in the previous sessions? A little bit, what matters are actually subjected to arbitration or not?
Yes, ma'am.
Yes, so I assume everybody knows that criminal matters are not arbitrable.
Yes, ma'am.
Yes, so once it does come to light that there is some matter that is actually beyond the scope, तो वो आपको as soon as, now this is a reasonable period of time. This is not, you cannot particularly determine कि हाँ 3 दिन में ही आपको रेज करना है. Why? Because there might be certain circumstances where आपको वो चीज पता लग गई है पर confirmation में time लग रहा है, and you cannot you wouldn't want to raise a challenge जो defeat हो सकता है, which is why you might wait a little bit of time. So this is open to interpretation by the tribunal, which is why, so now 2 points of time. One is जब constitute हुआ है under clause 2, तो आपको statement of defense से पहले section 16 की application में jurisdiction challenge करनी है. And number 2, during the proceedings कभी भी अगर आपको लग रहा है that this matter is not within the scope, तो वो कभी भी during the proceedings as soon as possible वो raise करनी है dispute. So far clear? Now, obviously, like courts have the power to condone any delay, the arbitral tribunal also, in either of the cases, admit a later plea if it considers the delay justifies. Condonation of delay, simply. Now, once the arbitral tribunal gets a particular challenge as to its jurisdiction, it has to decide itself, because that is what clause 1 says, that it is going to rule on its own jurisdiction. Once it has received an application under section 16, it has to decide whether it accepts the particular challenge or it rejects it. If it rejects it, it's fairly simple. They'll continue with the arbitral proceedings and they will give an arbitral awards. If they accept the challenge, then either they can obviously determine that वो dispute है जिस matter पे, that is beyond the scope, and they will not determine that matter, exclude it from its scope. And if they reject it, it's very simple. They'll continue with the arbitral proceedings. दूसरी party खुश है नहीं खुश है, because see, sometimes party use these particular tactics to delay the proceedings as well, which is what we have to prevent, because we are trying to make arbitration quick. So it will go on with the arbitral proceedings and it will make the arbitral award. Now, when that award has been made, so एक आपको टाइम पीरियड मिला आर्बिट्रल ट्राइब्यूनल की जो जुरिस्डिक्शन चैलेंज करने का अंडर सेक्शन 16, and that is 2 things. One, when the tribunal has been constituted, and secondly, during the proceedings जब आपको लग रहा है. उसके बाद, until and unless the award is made, you don't get to make a challenge on the same grounds. If it is a new matter that is beyond the scope, you may raise a challenge again. But on the same dispute, on the same matter that you think you have already challenged the arbitration, to challenge the jurisdiction, you cannot do that. You have to wait until the award is made, and then, as per clause 6, a party aggrieved by such an arbitral award may make an application for setting aside such an arbitral award in accordance with section 34. So section 34 is to set aside an arbitration award that has been given by a tribunal, which specifically has a ground that a tribunal has exceeded its jurisdiction. उसमें ground है to set aside that particular award. So if you think that you are not happy with the section 16 वाली application का result, you have to wait until that award is made, and then you will file a अब कोर्ट डिटर्मिन करेगा. सेक्शन 34 वाली एप्लीकेशन हमेशा कोर्ट में जाती है. सो वी आर नॉट आउस्टिंग द जुरिस्डिक्शन ऑफ द कोर्ट एंटायरली, वी आर ओनली डिलेइंग इट. हम फर्स्ट अपॉर्चुनिटी दे रहे हैं ट्राइब्यूनल को टू रूल ऑन इट्स ओन जुरिस्डिक्शन. जब वो कर लेते हैं, उसके बाद if you are still unhappy with that decision, then you may apply to court under section 34, and then there is a ground to particularly challenge that particular award. So far clear? This is basically, they have the first say on jurisdiction, and that say is going to be protected by the doctrine of separability. And it is only, we're only delaying, in fact, deferring court intervention in this particular case. So far, are we clear on competence, and separability?
Yes, ma'am.
Any questions? No? Should I move on to the next topic then?
Yes, ma'am.
Appointment of arbitrators?
Yes, ma'am. You can.
It's 5 already, yes. Now, and section 11 is actually very much connected with section 16, because हमने बात की है validity of arbitration agreement की. Now, appointment of arbitrators. We might think, and it might come across as कि जब arbitrators appoint हो रहे हैं, तो parties अपने मर्जी के, somebody who might have some interest in their particular case, कि जो हमें फायदा कर सकते हैं, हम उन्हीं arbitrators को appoint करेंगे. But that is not the case, because the act itself provides a lot of checks and balances to prevent any such interest. Now, first of all, Section 11 provides that a person of any nationality may be an arbitrator unless otherwise agreed by the parties. Again, obviously, almost everything is subject to agreement by the parties. So if they provide in their arbitration clause, it has to be an Indian, it has to be an Indian then. There is no embargo as such. Subject to subsection 6, the parties are free to agree on a procedure for appointing the arbitrators. So if it is a sole arbitrator, we might agree that I will provide a nomination and you will respond within 1 week. If you don't respond, it will deemed to have been confirmed by you. Yes, or if you don't respond, you will give a nomination. So again, parties are free to determine however they want to appoint their arbitrators specifically, and then specifically when there are 3 arbitrators. Failing any agreement of the parties in an arbitration with 3 agreements, with 3 arbitrators, both parties, they are going to appoint 1 arbitrator, and वो जो arbitrator होंगे दोनों party appointed arbitrator, वो तीसरे arbitrator को appoint करेंगे, who is going to be the presiding arbitrator. Specifically, presiding is only for the sake of carrying out the functioning of the proceedings. There is no different role as such, no extra remuneration, none of that. But both parties are going to appoint 1 arbitrator each, and Teesra is going to be appointed by those arbitrators, not by the parties then. Now again, we have arbitral institutions now, but they're not functioning as of now because we haven't come out with clear rules. So for the purposes of having arbitrators to choose from, these arbitral institutions exist. But if there are none, then High Court eventually appoints these arbitrators. In your introductory class, have you discussed ad hoc arbitration and institutional arbitration?
Yes, ma'am.
So pretty clear as to what arbitral institutions are and what they do. Do I need to reiterate that?
No, ma'am.
Okay, so we will move on from this. जो arbitrators के fee rate हैं, those are specified in the 4th schedule in India in our Arbitration and Conciliation Act. Again, if the arbitral currently and previously arbitral institutions did not exist, we have now incorporated them after the amendment of 2019, but still we don't have proper rules for them yet. So which is why it is still high courts here. High courts where the Chief Justice or is maintaining a panel of arbitrators, and they are usually appointed as arbitrators when you can't agree on the appointment of an arbitrator. Relevant provision that we are going to come to now is here. Now, if the appointment procedure in subsection 3 applies, this is if it is court appointed, failing any arbitration for 3 arbitrators. A party fails to appoint an arbitrator within 30 days from the receipt of a request to do so from the other party, and the 2 appointed arbitrators fail to agree on the 3rd arbitrator, then so 30 days दोनों parties को देने हैं अपने arbitrator appoint करने के लिए, and दोनों arbitrators को तीसरा arbitrator appoint करने के लिए. If that is not done, then 30 days के बाद either party can apply either to the arbitral institute. Since we don't have them yet, they usually apply to the High Court in domestic arbitration and Supreme Court in case of international commercial arbitration to appoint that particular arbitrator for them. Basically, court is then going to appoint your arbitrators. Fairly simple. So far, any questions? Okay.
No, ma'am.
Yeah, we'll keep moving on. If you have, please ask as and when you need to ask. And if in case of a sole arbitrator, the parties fail to agree on the arbitrator within 30 days, then either party can apply for provisions of, apply to either the arbitral institutions or High Court or Supreme Court to appoint an arbitrator for them. It's the same if you have agreed on a particular procedure and you don't follow that procedure, a party fails to act under that procedure, or the 2 party appointed arbitrators don't follow that particular procedure for appointment of the presiding arbitrator, and they fail to perform any sort of functions, then again 30 days के बाद you can apply to court to particularly appoint that arbitrator. तो either way, अगर parties की कोई agreement है और वो procedure follow नहीं होता है या appointment नहीं होती उस procedure के according, or if the statute is being followed because there is no agreement between the parties and then we can't follow the provisions of that particular statute, then you can also ask the court to appoint that particular arbitrator. Now, there was 6A here. It was added in 2015, the Amendment Act of 2015, and then omitted in 2019. This particularly clarified, and there was a legislative clarification, in fact, that जो ये power है to appoint arbitrators, it is not a judicial power, it is an administrative power. Why that is relevant is because your judicial review depends on whether any exercise of power by the courts is a judicial power or administrative power. Court has settled this and held that it is an administrative power.
Students, please bear with us. I think so. There's a technical glitch from ma'am's side. She, she'll rejoin. Raj, am I audible?
Yes, sir.
Okay, I think so. There's technical glitch from ma'am's side. She'll just rejoin. Just a minute. Yes, ma'am is back. She'll just try.
So sorry, today of all days, I'm suffering a lot of electricity issues. Yes, so I will go back to sharing. So we were at 6.8. Is my screen visible?
Yes, ma'am.
Yes. So specifically, this was obviously relevant because judicial review हो सकता है कि नहीं एक particular appointment of arbitrator का, but that's now been clarified. It is an administrative power. 2019 में ये specifically omit इसलिए किया गया था because 2019 में we introduced the concept of arbitral institutions. And जब arbitral institutions specifically appoint कर रहे हैं, this because they are now supposed to be appointing arbitrators. तो फिर इसमें सुप्रीम कोर्ट या हाई कोर्ट की एडमिनिस्ट्रेटिव पावर है या जुडिशियल पावर है दैट बिकेम अ रिडंडेंट क्वेश्चन बट अनफॉर्चुनेटली बिकॉज अभी इंस्टीट्यूट्स नहीं कर रहे रूल्स नहीं आए विच इज व्हाई इट्स स्टिल बट इट्स क्लैरिफाइड दैट इट इज अ particularly administrative power. I will specifically is my screen still visible?
Yes, ma'am.
Yes. So what are the bases? What would you as
No, the screen is not visible. I'm sorry.
no, not visible. Okay, let me try that again.
It's visible, Raj. Appointment, ma'am. You have shared appointment.
Yes, is the PPT available?
Yeah, actually it's too small.
Is it still
The font size is actually looking a little
okay?
small.
I can do that. I can fix that. Is that any better?
Yes, ma'am.
Is that any better?
I think my reception is bad, I guess.
Okay. Okay, so what are your considerations going to be as a party to an arbitration proceeding? Is one, and what are you going to think of when you actually appoint an arbitrator? And these are what are going to be relevant for you when you actually determine who should be appointed as an arbitrator. So the first thing that you're going to look at is how many arbitrators should it actually be, and that you are going to determine when you particularly draft your arbitration clause. So when you draft an arbitration clause, if it is something ideally, as somebody who is telling, I mean, is the legal counsel for a person who's entering into a contract, आपको there are a few things you have to look at. One is going to be how much of money am I investing in this particular transaction, and how much do I stand to lose if there is a dispute or there is going to be a breach. Ideally, if you have the money, you are going to opt for three arbitrators, because see, that's going to be a more comprehensive determination of your dispute. There are three people who are actually going to be looking at the dispute, looking at all of that you're presenting, and then arriving at a decision. But that would only be valid, and that would actually be, that's going to be smart if you have the money to actually afford all three of them. If it is a dispute which you think that I want to be resolved quickly, that is going to be with a sole arbitrator. So something that does not have a far-reaching implications for your business, that might not be, that does not need so much of time, then you might opt for a sole arbitrator. Mostly, for a lot of simpler business transactions, you might want to opt for a singular arbitrator, because what happens is that it is just the two of you that need to arrive at a particular decision as to who's going to be the arbitrator. If you don't arrive at that decision, you will go to court for that sole arbitrator. In case of three people, first you have to arrive at the appointment of an arbitrator, and it's not going to be that आपने अपना appoint कर दिया और दूसरी party को confirm नहीं करना वो appointment. It has to be both the parties agreeing to appointment of each of the arbitrators that you are party appointed be. It has to be confirmed by the other party. That is going to be a little bit time consuming, and then obviously the party appointed arbitrators have to appoint a third person, which is also then going to take a bit of a time. So if you think that your dispute is worth that time and money, that is when you want to opt for three arbitrators. But yes, obviously, three arbitrators obviously ensure that your dispute is looked at from three different perspectives of those three people. And they might have some technical expertise, they might have more experience. You might want to have, in case of those three arbitrators, you might even specify that one of them must have to have some particular technical education or technical experience. If it is something that has to do with a way that is going to relate to a very technical dispute, you will need that expertise. So this might help in having an expert on that particular tribunal. It might help in having somebody who's had years of experience in arbitration on that particular panel. So yes, that is the first thing that you need to determine, whether you want one arbitrator or you want three arbitrators. Secondly, what is the skill? Are you going to specify what the skill, the experience, or the knowledge of the arbitrators? Do you want somebody who's had 10 years of experience in this particular field, and only then they will be appointed as an arbitrator? You want to have somebody who's practiced in this particular field for a period of time, or who studied in this particular field for a period of time, who has had industry experience for that kind of dispute. So what is it? And this is going to be determined in your main contract, because this you will have to specify beforehand. Now, what you might think is that, again, this might make it very rigid to just appointing those kind of people. But see, if you are somebody who is selling some sort of or manufacturing some sort of goods or any products that do need some sort of technical background, you want somebody who actually has that experience to determine the disputes. You don't want any. Now, see, one of the reasons why we get very disillusioned by courts is because they don't know these specific matters. They have no knowledge of these things, factual matters, technical matters, mechanical law. Judges are only going to know the law. They will get experts to determine that dispute. You can obviously have experts come into your arbitral tribunal arbitration proceedings as well. But it saves you time in appointing that neutral third party being the expert themselves. There may be experts in the industry. You can have, that's what I was saying, you can have expert witnesses, but it just saves you time rather than calling a third person. If both the parties agree कि हाँ हमें ये expert चाहिए इस particular industry का to actually determine a dispute, because that person might be best suited to determine this particular dispute, we are going to appoint them as an arbitrator. They can be lawyers, obviously, they can be non-lawyers as well. They can be professors. You might have somebody who's been teaching some concept of mechanical engineering, because that has to do with that is related to your dispute. You can have somebody, again, language is more relevant in international commercial arbitrations because in translation, you might opt for English as the language that you're going to cover your particular proceedings in, but there is a lot that is lost in translation. So it might help you in having somebody who actually knows the language of one of the parties. One of the most important factors actually in appointing an arbitrator is availability of that arbitrator. Now, you might know somebody who's had 10 years of experience as an arbitrator, but that person is at one given point of time undertaking 5 arbitration proceedings. Do you think he's going to have the time to peruse your particular case, your dispute, with the same amount of time or with the same dedication and effort as somebody who's only dealing with another arbitration at a given point of time in a month? Yes. So, and availability is something that is so relevant because they are, as per the statute also, they are making a disclosure as to their availability. Because, see, arbitrations are supposed to be quick, very quick. I mean, comparatively to courts. But if the arbitrator is not available, they will never be quick. And obviously, then in the field of arbitration, there is reputation also plays a very big role because you might think that this particular person has undertaken uh, our arbitration proceedings. Their awards have never been set aside by courts. They are well-reasoned awards. That is something that is going to point to the reputation of that particular arbitrator. And then independence and impartiality, again, that is contained in the law as well. You have to be independent and impartial, and we are going to come to that because that is how you determine and how that that particular point that a party appointed arbitrator, a party might appoint an arbitrator hoping कि ये मेरे favor में मुझे award देगा. But that independence and impartiality disclosures have to be made. This we've covered already. I guess for 3 arbitrators, you have to appoint 1 arbitrator each, and then the chair is going to be appointed. These declarations or statement of independence, it's a disclosure that has to be given. We're going to just quickly come back to the acts that we were referring to. Can you see? Can you see my screen, please?
Yes, ma'am, it's visible.
Yes, we're back to the PDF, right? Arbitration Act.
No, ma'am.
Still the
Yes,
PDF?
ma'am. Yes, ma'am. For the PDF.
Yes. Okay. So now, Section 11 is the appointment, and Section 12 gives you the particular obligations of that particular arbitrator. You can even conduct, so we'll just quickly come back to this Declaration of Independence in the next slide. You can have, for our ad hoc arbitrations, obviously you can select any person to be a particular arbitrator. But for arbitral, if you're choosing institutional arbitration, then जो arbitrators उस particular institute में enrolled हैं, impaneled हैं, उन्हीं में से एक arbitrator appoint होगा. Nobody beyond that. For ad hoc arbitrations, obviously you're at liberty to appoint any particular person. But why people opt for institutional arbitrations is because it takes away a lot of the administrative work end of the arbitration away from the parties, which actually gives them time and effort to put towards presenting their particular case, because they don't have to determine a lot of the back end of the work, administrative work jo hai, they can focus on their particular dispute. And then you can obviously conduct arbitrator interviews as well for determining who should be appointed, and obviously provided that if they're a good fit or not, you're going to appoint them. Now, what are the obligations? This particularly is contained in Section 12 of our particular Act, of the Arbitration and Conciliation Act. They have to be independent as well as impartial. How do you prove their independence or impartiality? Impartiality specifically means that you obviously have no bias in the case, no bias on merits or towards parties. You have no interest in the case, personal interest, not in terms of determining the dispute, no personal interest in the dispute or in any of the parties. Now, that could be something like holding shares of a particular party, if it is a company listed by shares. Independence is, again, there is no particular financial or other interest in the outcome of the case, and no close relationship with any party. Close relationship, again, is defined under the Act. We're going to quickly come to it after in the next slide. What you have to do at the stage of at your appointment, and in fact throughout the process of arbitration, is disclose any sort of justifiable doubt, any circumstance that may raise a doubt as to your independence and impartiality. Now, one, it has to be done at the time of appointment, and then it has to be done throughout the proceedings as well. Circumstances might change, which may result in some doubt being created in the minds of either of the parties, which is why it is not that, again, that point that एक party तो वही arbitrator appoint करेगी जिससे उन्हें कुछ फायदा होगा. That is not the case. Because अगर ऐसा कुछ है, that has to be disclosed at the time of appointment specifically. Now, what are justifiable doubts? Justifiable doubts are those doubts which would persuade a reasonable third party that the arbitrator might decide based on facts other than the merits of the case. So anything beyond the facts and merits of the case, if you are deciding the dispute, that is obviously a justifiable doubt. However, there is no particular liability for non-disclosure. All that is going to happen, अगर आपका कुछ ऐसा, if there is any doubt as to your independence or impartiality, the only thing that will happen is you will be removed as the arbitrator. There is no particular liability because parties की agreement थी. इसमें statute की backing as such नहीं है कोई. Now, these particular lists are, we have these circumstances listed in Schedule 5 of our Act. Let me go back to that. We have it listed in Schedule 5. We'll quickly go to that as well, but here. So grounds for challenge. When a person is approached in connection with his possible appointment as an arbitrator, he shall disclose in writing any circumstances. This disclosure, this form is given in Schedule 6 to the Arbitration and Conciliation Act. They have two kind of disclosures. One, such as the existence, either direct or indirect, of any past or present relationship with or interest in any of the parties, or in relation to the subject matter in dispute, whether financial, business, professional, or any other kind of relationship or connection, which is likely to give rise to justifiable doubts as to his independence or impartiality, and such circumstances which are likely to affect his ability to devote sufficient time to the arbitration. So this is something that's very relevant, which the Act provides for, because we are looking to reduce the time in dispute resolution by arbitration. And in particular, his ability to complete the entire arbitration within a period of 12 months. So they have to give a specific disclosure. And isko prove karne ke liye, clause B ko, they have to specify which other arbitrations are they actually a part of. Because this is going to affect their ability to devote sufficient time. So fifth schedule is justifiable doubts. We're going to move to it. Disclosure has to be done as per the sixth schedule. I'm going to quickly move to the fifth schedule specifically provides for certain circumstances which will actually raise doubts as to the particular independence and impartiality. The following grounds give rise to justifiable doubts as to independence or impartiality. I'm not going to read all of them because you can refer to it after the class. But the arbitrator is an employee, consultant, advisor, or has any past or present business relationship with the party, has represented or advised one of the parties, or any affiliate of the parties. The arbitrator is a lawyer in the same law firm which is representing one of the parties. Even that is considered as a justifiable doubt. You might be working at the same workplace as one of the lawyers of the parties. The arbitrator is a manager, director, part of management, or similar controlling influence in an affiliate of one of the parties. if the affiliate is directly involved in the matter, in the dispute. So a lot of these, that's with the parties. Then there is a relationship of arbitrator to the dispute. The arbitrator has given legal advice or provided an expert opinion on the dispute to a party. You might have obtained their opinion and then tried to appoint them as an arbitrator because you know their opinion. The arbitrator holds shares either directly, indirectly in one of the parties or an affiliate of one of the parties that is privately held. A close family member has significant financial interest in the outcome of the dispute. So all of these circumstances actually give rise to justifiable doubt as to the independence and impartiality of the arbitrator. Now, what is the procedure for challenging? What are the grounds, in fact? You have two grounds for challenging. One is circumstances exist that give justifiable doubts, and he does not possess the qualifications agreed to by the parties. Clause B is going to be based on the qualifications that you agreed to in your arbitration clause, if you specified particular qualifications. This is going to stem from the statute. So if either of the things are missing, if you can challenge the arbitrator under section 12. Now, a party may challenge an arbitrator appointed by him or in whose appointment he has participated only for reasons of which he becomes aware after the appointment has been made. If you knew that some circumstances exist, or if you knew that he did not possess certain qualifications that you agreed to, and you still appointed him, then you can't go ahead. That is a stopple on you then. You can't turn around and then try to remove that particular arbitrator. I guess that's fairly clear. Now, seventh schedule specifically leads to is circumstances that will actually make an arbitrator ineligible for appointment. Those are again very similar to fifth schedule, so you can see those. Notwithstanding any prior agreement to the contrary, any person whose relationship with the parties or council or subject matter falls under seventh schedule, they will be ineligible as an arbitrator, to be appointed as an arbitrator. So yes, seventh schedule is something that is the equivalent of the red list. Now coming back to the PPT, I've specified red, orange, and green lists here. These are based on International Bar Association's guidelines on conflict of interest in arbitration, international commercial arbitrations. Let me quickly open that for you as well. 1 second, please. Please give me a moment. I'm just going to quickly open that as well.
Yes, ma'am.
Can you still see?
Yes, ma'am. Yes, ma'am.
Yes,
PDF is visible.
Is it still the PDF, the Arbitration Act PDF?
Yeah, yeah, ma'am.
yes, ma'am. Yes, ma'am.
Okay, I'm just quickly trying to change that. Is it still the Arbitration Act, or can you see the guidelines?
IBA guidelines is there, ma'am.
Yeah. So yes, these are the IBA guidelines, which actually are very similar to what we've actually based our particular fifth schedule on IBA guidelines. These keep getting updated from time to time. Now there are 4 lists in this. That is your red list, 3 in fact: red list, orange list, and the green list. Again, in internet, these are more relevant in international commercial arbitrations because you might want to be bound by these and not by any particular law, because you can be bound by these. Non-waivable red list are particularly those particular circumstances which you cannot waive at all. Parties don't have the option to derogate from these. If such circumstances exist, that person cannot be an arbitrator. So similar to a 7th schedule. Waivable red list is those wherein subject to the parties' agreement, they may waive that particular circumstances. If that exists, if there is some sort of interest, then that is going to again depend on the parties whether they want it to be a deal breaker or not. Orange list, again, something that is for the parties to determine. It is not mandatory to disclose, but again, this has those circumstances which mostly relate to past. So you will notice past 3 years. Yes. So past relationships, which you might want to overlook because they might not be relevant anymore. Green list obviously is something that you don't have to disclose as such, and also not a deal breaker in appointing an arbitrator. More or less, in domestic arbitrations, we are going to be following our fifth schedule and particularly seventh schedule. If you could just give me a moment, please. Yes. So far, are we clear on challenging on the disclosure that has to be made? What are the grounds for challenge? There is a specific procedure as well, which is listed, which is given under the Act. But if you want me to continue this, or I think arbitrability has been discussed already, right? It is given in my session coverage as well. Do you want me to continue with the challenge procedure, or do you want to open it for questions? Rohit sir, I'm open to either of the things.
Yes, ma'am.
Should I continue with the challenge procedure or should I open it up for questions now?
Ma'am, I think so. You can just summarize it and
Summarize the procedure? Yes, I can. I'll do that.
just summarize the procedure because we have to discuss about the mock wala also. Mock
Haji, which is why I'm asking. Okay.
Yes, ma'am.
Then
We
I'll
can sum up this and then we can just go on to the mock one.
take. Yes. So I'm not going to read section wise. That is something that is going to take a bit of time. But so quickly going through the procedure that is relevant. So you have two grounds. One is there is justifiable doubt, and one is they don't have the particular qualifications that you agreed to. Now, at the time that you actually raise a challenge, there are two things that the arbitrator has to do. There is freedom with the parties to choose whatever procedure they want to choose for challenging an arbitrator. If they don't choose a particular procedure, then obviously you have to your first point of time, that is जब arbitral tribunal constitute हुआ है उसके 15 दिन के अंदर अंदर आपको ये challenge raise करना है. If you don't raise a challenge, you will not then, I mean, it is a waiver under section 4. You can refer to section 4. If you don't exercise a particular right given under this act, it is deemed to have been waived. Or after becoming aware of any circumstances, that is later on, if you figure out that yes, there is a particular reason that is a circumstance that has arisen that may lead to a challenge, then at any time after becoming aware. Constitution of arbitral tribunal के सिर्फ 15 दिन बाद में again reasonable time has been given. When such a challenge is raised, ideally, I mean, one, to obviously save their reputation and not go into the entire challenge on determining if it is if it is a baseless challenge, then obviously that challenge will not succeed. But again, here, you might think that this is a person who already has an interest in this dispute, a person being a judge in their own case, because वो खुद ट्राइब्यूनल ही उस चैलेंज को डिटर्मिन करेगा. Two things can happen. The arbitrator can either withdraw from the office, or when a challenge has been raised by either party, या अगर दूसरी पार्टी भी उस चैलेंज को कंफर्म कर देती है, they have agreed to the challenge, then the arbitrator that has been challenged, उसका mandate खत्म हो जाता है. So either you withdraw yourself, or if the other party agrees, then you are not going to remain an arbitrator, because again, it is agreement of parties. Both parties agreed to appoint that arbitrator. Now both parties will agree to remove that arbitrator. Now, if neither of those things happen, then obviously the arbitral tribunal is going to decide on the challenge. If the challenge is not successful, similar to your jurisdictional challenge, if it is not successful, then the arbitral tribunal will continue the proceedings and they will make an award. Now, again, 34 में आप फिर बाद में जाके 34 में उस arbitrator की भी appointment challenge कर सकते हैं when you file an application for setting aside of an award that has been made. That is your challenge procedure. Two other things here as well. Section 14 में there are this specifically talks about the mandate of an arbitrator becoming terminating. So these are more or less two additional grounds. One is he becomes de jure or de facto unable to perform his functions, or for other reasons fails to act without undue delay. If a person falls sick, has to be admitted, he is de facto unable to perform his functions, and that too without undue delay. If the arbitrator dies during the proceedings, these are grounds that will obviously bring the mandate of of an arbitrator to an end. And then obviously if he withdraws willingly from his office, or if the parties under the challenge procedure had agreed to terminate his mandate. This specifically, but fairly simple. There are 2 points of time during the proceedings. One is जब tribunal constitute हुआ है, उसके 15 दिन के अंदर आपको challenge करना है. And secondly, at any time जब आपको लगता है वो justifiable doubt arise हो रहा है, it may so happen that when you were appointing an arbitrator, you did not know that arbitrator's close family member, or maybe the wife, held certain shares of that particular entities of that particular company. And with time, you have found out that yes, there is some sort of shareholding. That is something that is giving justifiable doubt, and then you can challenge as and when that came to your knowledge. That is particularly with respect to the termination of the mandate of the arbitrator. Now, of course, you need to substitute that arbitrator. So again, all of the same criteria that you followed, the same process to appoint an arbitrator, that is going to follow for a substitute arbitrator. The same qualifications that you needed for that arbitrator, those are similarly going to apply to this substitute arbitrator as well. Again, it is for the tribunal to determine कि हमें proceedings अब शुरू से चलानी है या जहाँ पे खत्म हुई थी, or where the mandate came to an end, do we resume from there? That is the tribunal's discretion. So far, for appointment of arbitrator, the procedure is under section 11 for appointment. For challenging, for disclosure and challenging the arbitrator, it's under section 12 to 15. Jurisdiction is in section 16, and the primary right to determine jurisdiction is with the tribunal itself. Any questions? More or less, I have covered almost everything that is given in your session for today. If we have any sort of questions, I'll quickly go back and finish here as well. So again, red list is divided into two. Orange list is situations that the arbitrator must disclose, and that has to be a timely objection by the opposite party. Green list is even if in the eyes of the parties disclosure should be made, arbitrators do not have to disclose. There is no mandatory obligation to disclose. This is generally the rule that is followed. If there is any doubt as to should I disclose this or not, it is obviously a safer bet to disclose that particular thing which you think might become an issue of concern later on. Yes.
Any questions, students? You all can unmute and ask. Yes, Raj, any question?
No, sir.
I had a question regarding an arbitrator's bias. Suppose an arbitral tribunal issues a decision favoring one party, but later
Yeah.
it is discovered that the arbitrator had a business relationship with that party. So now the aggrieved party challenges the award. But what is the difference between real danger of bias and mere apprehension of bias?
Yes, so that will be something that has to be determined on the facts. But your criteria again, whether it is just mere apprehension or real danger of bias, that is going to be determined from a reasonable third person's perspective, from something that you and I might see. Again, mere apprehension is something that you might think is going to happen. I might think that See, for me, throughout the proceedings, I might be thinking ये तो दूसरी पार्टी का appointed arbitrator है. इसके पास कोई ना कोई फायदा इससे कुछ मिल रहा है. They might decide against me. That is mere apprehension. That is baseless. Which is why there has to be, you have to particularly justify your doubt with particular circumstances, which are going to again depend on the facts. So, like you said, if you know that there is a business relationship, you will have to prove that. It is not simply going to be a baseless allegation, which is why there are those grounds listed. Because mere apprehension तो हमेशा हो सकता है. Mere apprehension आपको जज साहब से भी तो होता ही है. Yes.
Yes, ma'am. Understood. Thank you, ma'am.
Any other questions on today's?
Yes, students, any questions?
Ma'am, can a non-signatory be bound by an arbitration agreement?
Of course they can. Yes. So this has been clarified now, and specifically the relevant question I'm guessing is arising from that group of companies doctrine. We discussed two of the relevant arbitration doctrines today. One was particularly a doctrine of separability, and one was competence. The third doctrine that is usually relevant in arbitrations is the group of companies doctrine, which is from what non-signatories, which is what actually talks about non-signatories. I'm going to quickly again come back to section 8 and share section 8 with you because you asked about non-signatories earlier. You can see my screen?
Yes, ma'am.
Yes. Section 8 specifically says any party to the dispute or anybody claiming through a party. That anybody claiming through a party, can that not be, or any person claiming through or under him? Can this not be a non-signatory? Yes
Okay,
or no?
ma'am. Thank you, ma'am.
No, I am going to explain, and I'm just quickly asking if you would happen to think that is it only going to be an agent? Can it be a subsidiary? Can it be an affiliate company? But of course, if the dispute affects them, right? It cannot be a random affiliate of a particular or a subsidiary of a particular company or a party to the dispute, unless and until they have a particular interest in that dispute. This is how they are going to be bound under section 8 and obviously 11 as well. Let me quickly now, I'm going to give you a particular case reference. Earlier, and this has been now laid to rest in Cox and Kings, a very recent judgment, November 2024. Cox and Kings Limited versus SAP India Private Limited. This particularly talks about the group of companies doctrine. It says that this group of companies doctrine is specifically rooted in Section 7 of the Arbitration Act and Section 2, because Section 7, and we're going to come right here. Commercial relationship between signatory and non-signatory part. I mean, I'm going to explain it before we actually move on from this. Now, Section 7 specifically says, does an arbitration agreement have to be signed? That's my question to
Yes,
you.
ma'am.
Does it have to be signed?
Yes, ma'am.
Compulsorily. It has to be in writing for sure. Yes? And it is deemed to be in writing if it is in a document signed by the parties. So does an arbitration agreement have to be signed? Don't we consider a clause in an arbitration as a separate arbitration agreement?
We do, ma'am, but it has to be signed, right? Like if the document is signed, that is why the
That
arbitration
is
clause
enough.
is valid.
So does there have to be a separate signature on that arbitration clause?
No, ma'am.
No. So which means that it is not mandatory that it is signed. In an email, when we're talking about an exchange of letters, telegrams, or other means of telecommunication, including electronic means, if you and I agree between the two of us, we already had a particular main contract transaction हमने execute कर ली है, और अलग से email पे we are determining that any dispute that is going to arise with respect to that transaction that we executed, we are going to refer it to arbitration. Is that not a valid arbitration agreement between both of us? As per clause.
Ma'am, it is because the intention to arbitrate is there.
Absolutely. तो वहां पे signature तो है ही नहीं.
Yes.
Right? तो ये signature की requirement अगर नहीं है, which means non-signatory parties, who have signatory parties कौन है? That have signed a particular agreement, correct? But
Yes, ma'am.
non-signatories are those that have not signed it. Now, in today's world where there are such complex transactions that are happening, there might be a multi-party transaction, joint venture में. There might be more than two parties. There might be somebody who's not signing. Subcontractors होते हैं. Do they sign the main contract? No, they don't. But they still become bound by the arbitration clause that is applicable to the signatory parties. Why does that happen? Because it is based on this particular principle that the intention of the parties was to go for arbitration. And with respect to that transaction and how many ever parties are involved in that particular transaction. Earlier, what was prior to this settlement of this particular dispute, what the case was, and we followed chloro controls before this. Chloro controls versus Severn Trust. It's a 2013 judgment, जिसमें कोर्ट ने 3 चीजें बोली थी कि आपको ये 3 चीजें चेक करनी है to actually bind non-signatories. One is that there is a direct relationship of that non-signatory with a signatory. And number 2, there is commonality of subject matter. And number 3, it is one composite or related transaction. Now, the second part of why I refer to section 7 was, who is a party here? A party to an arbitration agreement. Does it say it has to be a signatory to an arbitration agreement?
No, ma'am.
No. So reading section 7 with section 2H, section 7 says it can be in the form of emails. It does not have to be signed. Yes. And then it says a party to an arbitration agreement is anybody who's party to that arbitration agreement, not necessarily signatories. So in Cox and Kings, the Supreme Court actually based this group of companies doctrine. Actually, the basis was found in these two sections particularly, 7 and 2H. Because 7 में कहीं नहीं लिखा कि आपको signed arbitration agreement चाहिए, और पार्टी को डिफाइन किया गया है एज अ पार्टी टू एन आर्बिट्रेशन अग्रीमेंट, सिग्नेटरी नहीं है. Now, particularly then it was clarified in Cox and Kings that, see, one, you have to see the consent of the parties to that arbitration agreement. For example, non-signatory के क्या examples आपको पता है? One can be a subcontractor.
Yes, ma'am.
One could be a related party. Somebody who might be providing me goods and then I am using that raw material to further manufacture the goods and give it to somebody else. So my obligations are going to be dependent on that other party. It is a composite transaction. Yes?
Yes, ma'am.
So specifically, again, non-signatories. Your question was, can non-signatories be bound by an arbitration agreement? You have to look at the consent. जब आपने transaction की थी, was that non-signatory party who didn't sign it, but who is involved in that particular transaction. उनकी intention, और दोनों जो signatories हैं, उनकी intention थी to bind that non-signatory. It is going to depend a lot on the facts of each case. Through and under, पहले जो हम discuss करते थे 8 में, जो chloro controls में कहा गया था, that court said has very limited application. Where is it? right here. So the court in Cox and Kings said, and this has now been laid to rest because this is now a five-judge bench that has determined in Cox and Kings that yes, you can bind non-signatories. It is basically a consent-based principle, and it also has independent existence of its own. You have to prove one, the existence of that arbitration agreement, not necessarily कि आप signatory हो. आपको बस prove करना है कि एक valid arbitration agreement है, और party is anybody who can be a party to that arbitration agreement. Now, for example, you and I entered into that arbitration agreement over email and I CC'd two of the other subcontractors. Is that a valid arbitration agreement? And was my intention to also bind them?
Yes, ma'am.
Exactly. So aren't they did not sign that particular contract between the both of us. So why shouldn't I bind them?
Understood, ma'am. Thank you so much, ma'am.
Okay. Any other questions?
Hello, ma'am.
Hi, Raj. Yes.
Am I audible? Yeah. So, considering all this the complex nature of the arbitration, are the parties better off opting for institutional arbitration rather than going for an ad hoc arbitration?
See, in terms of money, institutional arbitration is going to be more expensive. But if you have that sort of money,
Yeah,
why?
but everything is in place already. So,
Absolutely. Everything is in place. You don't have to figure out the administrative work of an arbitration. You know that there is a.
wouldn't that be better for serving swift justice?
Absolutely. But see, not everyone can afford the fee that is going to come with an institutional arbitration. And unfortunately, for domestic arbitrations currently, our institutions are very limited in their scope. Specifically, I mean, again, institutions that have been recognized by Supreme Court and High Court. We have plenty of arbitral institutions in India, but those are private entities. You can opt for it, and there are they have niche areas as well. There are some very particular institutes that deal with one category of disputes only. But again, the kind of disputes that are arising today, we need to, in statute, although we've recognized under Section 43 of this Act, of this Act, we've not really put it into force entirely, which is what is problematic here. But yes, institutional arbitration any day would be a better fit for somebody who can afford it.
Mm-hmm. And in the case of ad hoc arbitration, are there any guardrails in place so that things function smoothly?
Absolutely. So, see, throughout this act, it says the parties are free to agree on whatever procedure they want to apply with regard to everything. Well, appointment of arbitrators, challenge procedure, everything, right? If you don't provide for any of that, you are going to refer to the seat, to the procedural law that is going to be applicable to that particular arbitration. Because that is what is going to determine how that particular arbitration is going to function. So, for example, we discussed section 8. 8 is mandatory. We'll go to 11. Here.
Mm-hmm.
A person of any nationality may be an arbitrator unless otherwise agreed to by the parties. So they are free to agree on whatever they want in that clause. If they don't agree to anything, then you are going to follow this. So failing any agreement referred to in subsection 2 in an arbitration with 3 arbitrators. So we do have some guardrails. Again, please note, part 1 of this act is only applicable to domestic arbitrations where both the parties are Indians, or where in an international commercial arbitration, the parties have chosen India as the seat. Has this whole seat and applicable law been discussed in your previous classes? I think
Yes, ma'am.
yes.
Lex loci, right?
Yes, lex arbitrary, lex okay, all of these things. So
Yeah,
yes,
Mr. Abraham mentioned it yesterday, lex loci, yeah.
yes. So specifically, what you choose as your seat is going to determine what is the law that is going to be applicable to your arbitration proceedings in an arbitration, international commercial arbitration. Now, unfortunately, India as a country is not very pro arbitration. We have a lot of court intervention. We have a lot of loopholes still where courts do come into picture and the whole process gets delayed. Enforcement is a very big issue. So, which is why in most international commercial arbitrations, people are choosing foreign countries, foreign places as seats. London is favorite. Singapore is something that's very
Singapore, yeah.
yeah, it's very arbitration friendly. So yes, everybody is going to opt for those. And then when you opt for Singapore as a seat, you're going to apply Singapore's Arbitration Act as those guardrails if the parties have not specifically mentioned anything. Any other questions?
Okay, thank you so much.
You're welcome. Any other questions?
I think some of the questions we can just jump into the mock arbitration.
Yes, mock arbitration.
Yeah, for the participants, I have shared the mock arbitration problem on your groups. So as ma'am is discussing, just refer to that problem. Yes, ma'am.
Yes. So have any of you participated in an arbitration before? Anybody?
No, no,
No,
no.
ma'am.
Have you witnessed any arbitrations?
No, ma'am.
No? That's okay.
Maybe in TV shows, probably.
Yeah, that's okay. So specifically, I mean, arbitrations work pretty much how courts work, but it is a bit more relaxed, less formal. It does seem like it's going to be something very extraordinary. It's usually not. You're sitting on a table. It's like a conference room. That's you. I'm telling you the setup of a particular place. Again, it may vary from arbitrator to arbitrator, but these days everybody, all arbitrators like to enjoy a little bit of fancy conference room vibe. So yes, it's mostly going to work just how a court works. There is a particular format to arbitration proceedings. Again, usually competitions involve two questions, two parts of a particular matter of a full, I mean, mock situation. One is the procedural aspect, and one is the substantive aspect. Can anybody tell me the difference if they know the difference between these two? Have you participated in mock in moots? Anybody? No? So yes, procedural are basically matters regarding the jurisdiction. And now jurisdiction, because under section 16, jurisdiction is going to be determined by the tribunal itself. So you will raise that jurisdictional challenge to the arbitral tribunal itself. Ideally, Rohit sir, are they going to be divided into groups?
Yes, ma'am.
So two speakers.
By tomorrow, we'll form the groups, ma'am.
Two speakers and one researcher?
Yeah.
How is it working?
Ma'am, I suppose that it will be two speakers and one, I think so the person will give the judgment.
Okay, so one arbitrator.
Yeah, one arbitrator, two speakers.
Okay, so yes, for arbitrators, again, we discussed today, you've been appointed. The first thing that you're going to do is give your disclosures that you are not related to any party in the form that is given in the sixth schedule. And for both the parties, again, two speakers, you are going to ideally divide your arguments into two parts. One is going to be the procedural, which is again, कोई किसी भी तरह का अगर आपको कोई challenge करना है, section 16 challenge, whether that or whether appointment of an arbitrator. Those are going to be your procedural bits. Substantive are on the dispute, on the facts that have been given in your particular problem. Now, I believe your problem is an international commercial arbitration, and the seat is Geneva. So, yes, there are a few things that you're going to have to refer to for this particular arbitration. Again, so one foreign party, it is going to be an international commercial arbitration. What is going to be relevant? You're going to have to look on the basis of what is applicable in Geneva. It is readily accessible. But again, on the basis of the facts that are given to you. It is fairly simple. You can go through it if you want to see. It's going to work in a bit again like a moot court works, but there are none of the formalities. You're going to be referring to the ICC rules, which is again what is going to determine how your proceedings are going to be carried out. Two, you're dividing your arguments on the basis of the procedure. Claims उसमें दिए हुए हैं for your reference, particularly facts that you have to argue on. They've also been specified. So yes, the party that is going to be the petitioner, which is Global Tech, you have to first invoke your arbitration clause. Only then will you be referred to arbitration. So yes, you have to follow the basis of that particular arbitration proceeding. Invoke that. If you want any interim measures, you follow that under Section 9 of the relevant provisions in, again, Geneva, because that's your seat. And that is what is going to determine what law is going to be applicable to your proceedings. But fairly, you shouldn't, I mean, there is nothing that is going, there's no your lordship, your honor, or anything. It is just sir and ma'am, more relaxed. You have to determine the laws that are applicable, although those are very clearly specified. But you have to differentiate as to substantive को क्या apply कर रहा है, because it is specifically stating that the SPA is governed by the laws of India. So that is what is going to determine the merits of the case. And the ICC rules are what are going to be applicable as the procedural law that is going to be applicable. Which is why, do you want me to share the problem? Sir, I think you may also share the problem.
Ma'am, if you can again share it, or if there will be a problem, we'll cancel.
The problem is actually shared with the students on the groups.
Okay.
So you want me to show it over here?
No, I don't think so. I mean, I don't want to give everything away. I mean, that's what it is for them to determine after this class. But which is why I'm just giving you a brief, just briefly as to how you should go about it. You have to go about it as you would go about it for a moot, which is pick up the facts, see what are the relevant facts to your particular party, what are facts that don't help you at all, and how you might want to agree on something that is already formed as an issue in this. But yes, that ideally you should divide it into two parts, because again, arbitration clause is a separate agreement. Separability में ये भी है that the purpose of separability is not only to shield that particular arbitration clause from invalidity of the main contract, but also to provide that flexibility कि हम arbitration clause पे कोई और law applicable कर सकें as compared to the main contract. So particularly in this problem that has been shared with you, the main shareholding contract, SPA, share purchase agreement, is being governed by the laws of India, whereas your arbitration is being governed by the ICC rules, and the seat is in Geneva, which means there are two different laws applicable. So a different law applicable to the procedural aspect and a different law applicable to the substantive aspect, which is the merits of the case. So that is something that you have to clarify in your arguments. And for the arbitrator, you obviously the award that you have to give. Firstly, you have to make your disclosure. If there are any challenges as to jurisdiction or your appointment, those are the first things that have to be determined first. Any questions with regard to this? So anything, Rohit, sir, anything else that you want me to cover?
Yes, students, any doubts? Because you'll have to participate in the arbitration, mock arbitration. So is it clear? As ma'am has told, it will be just like the moot court. So any doubts? Students, because you're going to participate in the same.
Yeah, hi, Raj here, ma'am. How are
Yes.
these proceedings different from a regular court in terms of the language? Um,
It's less formal, much less formal. You can,
yeah,
yeah,
yeah. Is it like a lot more casual than?
not a lot more casual, but fairly casual because you don't have to refer to them as your honor or your lordship. None of those formalities. You don't have to ask to approach the dais or, thank them. You don't have to stand for your prayer or any of those things. So, yes, more casual, but not entirely casual that you can show up in your jeans. You still have to be formally dressed. You have to have your documents in order because specifically in India, unfortunately, we are still court-appointed arbitrators are still those retired High Court judges. So yes, they
Mhm.
expect some sort of decorum in that particular proceeding, but more or less not as formal or rigid as the court. But again, no third parties, obviously. These are entirely going to be confidential. They're not going to entertain any random persons walking in because obviously it is going to be at a venue of the party's choice or the arbitrator's choice. So, yes, not everybody will have access to that as compared to courts. No media, no recording, all of those things. That's how, I mean, obviously, it's a private dispute resolution mechanism. So, it is going to remain private.
And is there any oversight body that is in place that supervises everything,
Uh,
even the process? Is
it
there
is,
any judicial oversight?
of course, there is. See, like I said, Section 16, even though it gives the arbitral tribunal the power to determine its jurisdiction, it's going to decide the challenge. Eventually, they are going to be answerable under Section 34. See, a lot of the arbitrators, their reputation is going to depend on whether the award that they are giving has it been set aside or not. Because how else do you determine whether and what are the grounds it was set aside on? Because once it goes to court, it becomes public information, correct? So once your award has been set aside, that is going to play a role in determining how good of an arbitrator you were. Because all of those things that may have led to any sort of partiality or, I mean, non independence of the arbitrator, they will come to light in court. So, yes, there is judicial oversight at every stage, in fact. And unfortunately, in India, that judicial oversight ends up being
So
interference.
yeah, so who holds their feet to the fire, ma'am? Like, is the judicial system?
See,
Um,
yes, eventually, but during the arbitration proceedings, there is not going to be any sort of interference, right? It is only afterwards. You are trying to give that opportunity. But why that becomes why everybody who's going to be involved in those arbitration proceedings tries to behave as one impartially and independently is because they know that eventually they are answerable to that court.
so
Because,
if the big numbers are involved, like uh, really big amounts of big money is
of course,
involved.
it doesn't, then that sort of corruption is permeates through the entire judiciary as well.
Hmm.
That is something, I mean, I have seen an arbitration where evidently there was an arbitrator who got paid off. But what more
Okay.
can you do other than file a set aside proceeding in the court? I mean,
Okay.
unfortunately, I mean, if we have this sort of bribery permeating the entire judiciary, who then these are just neutral private parties, third parties that the parties are appointing. They are obviously prone to all of this as well. I mean, that is
Okay.
something that obviously comes out in practice, but yes, well-seasoned arbitrators, somebody who's been practicing in arbitration, has experience, they will try to reduce that sort of um, that sort of again, I mean, whatever sort of corruption that might come arise to a minimum, so that it doesn't become that obvious. And to be honest, I know the person, I mean, the arbitrator who took all of that money in the arbitration that I had witnessed. There was one session that happened at his house, and he had the most simplest of cars, one-story house. And I also know how much money he took. So they will not make
Okay.
it visible. Yeah, yeah. I mean, reality is very different from what it is on
Hmm.
paper, right?
So
In
is the accountability, so do they take advantage of this whole thing that the accountability is not really
There
They're not
yeah, there is no liability as well, right? I mean, if I don't
exactly.
disclose,
So
if I don't
if you're
disclose,
not held to account, doesn't that give rise to all these malpractices?
the malpractices exist within our judicial system as well, don't they? And how are we holding them accountable? Not only judicial system, everywhere, everywhere. So how far, I mean, a particular person is going to go. But again, you know what? When you find out, it will affect their career as an arbitrator, because then the number of arbitrations that they get will start reducing. The number of parties that start confirming or approving their appointment will start reducing, because they know that this party is going to be biased to somebody who's appointing them, which is why we have the challenge mechanism. And more or less, it ends up, I mean, it ends up succeeding. And if it doesn't, then court will intervene at Section 34. And in fact, when you apply it under Section 34, so once you challenged under Section 12, that challenge failed, and then you again challenged to set aside that award under Section 34 on the ground that the appointment of the arbitrator was invalid. The court can even determine whether that arbitrator is entitled to his fee or not. So when you know, so that is the accountability.
Okay.
You know that
Okay.
your fee might be deducted, or you might not be entitled to your fee at all. So there are certain penalties that the court has the power to grant. That is how, I mean, they try to keep them in check.
Mm-hmm.
Yes.
So that's how their feet are hold to fire. Okay. Okay. Thank you, ma'am.
Yeah. Any other questions? No? Any questions regarding the problem?
I think
So
so.
one more question. Why is I'm sorry, can I ask the
Yes.
question? Ma'am? Why is it still not mainstream, ma'am? The arbitration. Yeah.
Because a lot of the people,
Why? Yeah. Why is it's not mainstream yet? And it's very unfamiliar, uncharted territory for a
because
lot of us.
the big corporations they don't trust arbitration being free from court interference, so they don't opt for it. And
So to going forward, do you see that it will be
yes, we are moving. Thankfully, the Supreme Court has been constantly giving us judgments that are pro arbitration, with, in fact, Cox and Kings being the most recent one. A lot of the judgments, thankfully, are now that are now coming from the Supreme Court and High Courts. You may look at Delhi High Court judgments. Delhi High Court is the most pro arbitration High Court that the country has. So yes, we going forward, we have actually come a long way from what we were when our Arbitration Act came in. Going forward, hopefully that will only continue increasing, because yes, parties now, there are foreign parties that are opting for India as well, and to actually cater to that, we need to be equipped as well. So that is the line that now the Supreme Court is also arriving at, fortunately. But we are still I mean, we're far away from where Singapore is, or where London is, or where Geneva is, even for that matter.
Okay.
Yes. Any other questions?
Ma'am, can you please tell us what do you specifically expect to see tomorrow?
Tomorrow in the mock?
Yes, ma'am.
I don't, I mean, I think Rohit sir and Shubham sir would be better equipped to answer that question.
Okay, students, regarding the mock, the rules and regulations will be shared on the group. Actually, we have just to introduce the problem. So the technicalities of the problem have been discussed. So as ma'am said that it is going to be like a moot court only. There will be two parties arguing on behalf of the uh, companies. There will be one arbitrator. Will divide you into groups, and into three people will be participating on behalf of one group. You'll have to decide. So all the rules will be given in your group. So that will be discussed over there. Okay?
Yes.
Okay, so ma'am, thank you, ma'am. The
Thank you.
session was quite enlightening one. So now I would request everyone to please switch on your cameras for a group photo. Yes, everyone. Okay, thank you, everyone. So we'll start with our closing session. विवेकनिष्ठाय बुद्धिय सात्य न्यायमेव सदा उदीपम निर्णायन सिद्धांते जन कल्याण सिद्धये। जब बुद्धि विवेक में स्थित हो तो न्याय ही सदा अधिपति बनता है। सही निर्णय के द्वारा जन कल्याण ही सिद्ध होता है। Over the course of this session, we have explored the importance of arbitration agreements and a glimpse of mock arbitration by ma'am, which has to be held on the last day. Madam, your expertise has really churned the minds of the participants, and really it would be helpful to them in raising their career graphs. At this juncture, it is my privilege to extend a heartfelt gratitude towards our Dean and Principal, Dr. Ujjwala Bendale ma'am, our Vice Principal, Dr. Jyoti Dharam ma'am, IQSA Coordinator, Vidya Dhere ma'am, and my colleague, Mr. Shubham Tripathi, whose tireless efforts have made this program a successful one. Also, a thanks to our student coordinators, Ansh and Priyanshi, for their continuous efforts. A special thanks to our today's resource person, Advocate Kirpan Dhariwal ma'am, whose valuable insights and academic experience will inspire us to embrace arbitration as a ever evolving practice of law that upholds justice with dignity. Over to you, Shubham sir.
As we close, yes, yes, somebody is saying something.
No, sir.
Okay, so as we close today's session, let us remember the essence of Saamanjasya, the spirit of balance, fairness, and dialogue. May the lessons we have gathered today not remain confined to theory but guide us in our studies, our practice of law, and in the way we handle conflicts in our everyday life. Let us carry forward the idea that true justice is not about power but about peace. Not about silencing, but about listening, and not about division, but about harmony. Thank you all once again for your presence and participation. We look forward to meeting you in tomorrow's session with the same enthusiasm and spirit of learning. Until then, stay safe, stay inspired, and have a very wonderful evening ahead. Thank you, everyone. Thank you for joining. Thank you, ma'am.
Thank
Thank
you.
you so much.
Thank you, ma'am. Thank you, participants.